New York State Racing Parimutuel Wagering and Breeding Law, Section 102, provides that the New York State Gaming Commission shall consist of 7 members, appointed by the governor, by and with the advice and consent of the Senate. 5 members having been confirmed by the New York State Senate affords the commission an ability to establish a quorum and undertake action. This present meeting of the commission is now called to order.
John Crotty.
Ms. Secretary, will you please call the roll?
My apologies. John Crotty.
Here.
Peter Machete.
Here.
John Bacumba.
Here.
Barry Sample.
Here.
Todd Snyder.
Here.
Ms. Secretary, will you please have the record reflect that a quorum of qualified members are present, thus enabling the transaction of business. Given the absence of a designated chair, would the members like to select a member for the purposes of presiding over today's meeting?
I nominate John Crotty. Second.
Okay.
We need to have a vote.
All in favor, say aye. Aye.
John?
Aye.
We're hoping for one of the dissent. Well, thank you very much. The first item up today is consideration of minutes from the last meeting we had on September 10th, 2015. The minutes have been provided to the members in advance. At this time, I would ask if there are any edits, corrections, or amendments. Being that there is none, move to
So moved. So moved.
second. Second. Vote.
Aye.
And the minutes are. Next up is the report of the Executive Director, Mr. Williams.
Thank you, Commissioner. Given the length of today's regulatory agenda, I'd like to keep this a little brief. As I mentioned during the last meeting, I had indicated that staff would provide an update on the casino licensing timeline and process. As you're aware, the regulations that enable the Commission to award licenses go into effect next Wednesday, September 30th, when the notice of regulation adoption is published in the State Register. By mid to late October, staff anticipates that we will have completed the suitability reports that include an analysis of the background investigations of the prospective licensees and principal management staff at each project. Staff is also in the final stages of compiling and reviewing all post-selection updates to the 3 selected entities' applications. These updates include, but are not limited to, the addition or replacement of key personnel, changes in any project financing structure, alterations to the project design, and more. A summary of all these changes will be assembled for your review and consideration as well. Staff has also been working on the license documents themselves, which will be akin to comprehensive contracts. Once all those components are in place and fully implemented, the Commission will be in a position to formally consider licenses. You remain on track to take licensing action by the end of the calendar year. With respect to the next set of casino regulations, staff continues to develop additional materials for your consideration, which will include surveillance requirements, game rules, disability access, workforce development, problem gambling, etc. We anticipate shortly at an upcoming meeting, you'll start seeing some of those materials as well. Finally, there were 2 meetings since our last time that we held a commission meeting that might be of interest to you. Last Friday, the Gaming Facility Location Board conducted their public comment event at SUNY Broome for the 4th license request for application process. The meeting, which lasted over 3.5 hours, heard from over 40 speakers. The board now has all materials necessary for them to commence deliberation. And in fact, they have scheduled a meeting next Wednesday to begin their internal discussions. Lastly, the Responsible Play Partnership, which is the group that comprised of representatives of the Gaming Commission, the Office of Alcohol and Substance Abuse Services, and the New York Council on Problem Gambling, conducted the 3rd in their series of Let's Start the Conversation events, which brings together regional gaming operators and problem gambling service providers to discuss issues and opportunities that lie ahead given the state's changing gambling landscape. The well-attended event, which took place in Sullivan County, will be followed up with a new event in the New York metropolitan region. Lee, do you have a date for that?
Tentatively November 19th.
November 19th. We'll get that out in advance to you guys as well. If anyone has any availability and would like to stop by the event, we would love to host you. Mr. Chairman?
Thanks, Rob. Okay, first item up is rulemaking. New York State Racing Parimutuel Wagering and Breeding Law authorizes the Commission to promulgate rules and regulations as deems necessary to carry out its responsibilities. In that regard, the Commission will, from time to time, promulgate rules, rule amendments pursuant to the State Administrative Procedure Act. We have a very extensive list of rulemaking today. Rob, will you please outline the first item?
Yes, sir. Item 4A for Commission consideration is conditional adoption of a rule allowing for the introduction of a new wager type for the lotteries division, numbers and win for draw games. The division's regulations presently set forth existing wager types for each of those games. The division, if you recollect, would like to offer new wager types called close enough. This new wager would allow a player to collect a prize if one or more numbers of the player selects differs by 1 digit from the winning number in a particular numbers or win for drawing. This rule was proposed by the Commission at the meeting of May 26, 2015, was published in the State Register on August 19th. The comment period for this proposal closes on October 5th. The staff recommends a conditional adoption of this rule proposal, with the condition being that no substantive comment is henceforth received.
Commissioners, any questions on the adoption of the amendment to the existing rule regarding new numbers and win for lottery game wagers?
Yes, Mr. Chairman, if a comment is received, will that be circulated to us and is put on hold?
If it's a substantive comment, yes.
Who makes that determination?
Counsel's office does on all of the rulemaking things.
I think if we get any comment, we should distribute it to the commission.
We can certainly do that.
Makes sense. Before it goes.
Before it's considered to be formally adopted.
I think that's right.
You okay with that, Pete?
Fine.
Right.
Yep, fine, good.
This,
You guys were shaking your head, so it's,
yeah, no. I think that's a good idea. It's a version of everybody gets a trophy now, right? Close enough? There you go. All right, with the stipulation,
Move to
John.
repeat the chairman.
Yeah, son. Let me propose it. Motion to adopt these amendments with John's comments.
So moved. Second.
All in favor?
Aye.
The motion carries. Rob, would you please call the next item?
At a previous meeting, the Commission was to consider a draft amendment to the regulation governing bonding requirements for video lottery gaming agents. You deferred consideration of this after I mentioned that I had received individual concerns from several commissioners regarding the proposed language. During the intervening time since the meeting, staff has revised the proposal to address those concerns. While I outlined the theory at the last meeting, or 2 meetings ago, I think it's appropriate to place that information again on the record. Since the commencement of video lottery gaming, agents have been required to provide a bond that corresponded with no less than a defined percentage of 5 days estimated average daily net win. The percentage used during the last decade had been 65%, which was set to mirror the state's statutory revenue retention from the facilities. That is net win minus the 35% agent and vendor retention. Since establishment of that initial percentage, the laws have been changed, modifying agent and vendor retention. In general, the agent and vendor retention is no longer 35%, and the state retention is no longer 65%. The agent and vendor retention and the state retention now vary at each video lottery gaming facility. Amendment of this existing rule would allow the flexibility to require bond coverage from each video lottery gaming facility to be commensurate with the state retention percentage at such facility. While the existing rule allows commission staff to grant waivers from the 65% requirement for good cause, staff believes that amendment of the rule to make the bonding requirement consistent with the original intent to secure 5 days of the state's share of net win at a facility is appropriate. Staff recommends proposal of this rule amendment.
Commissioners, are there any questions on this amendment? Hearing none, can we have a motion?
So moved.
Second.
All in favor?
Aye.
Aye.
Any in the negative? Motion carries. Rob, will you please call the next item?
Sure, as item 4C, for commission consideration is a proposed amendment to an outdated standardbred rule. The proposal would allow the commission to permit a standardbred horse to race for 30 days longer without a recent qualifying race when inclement weather or other unexpected events interfere with racing. The proposal would also delete an archaic reference to a racing calendar of June to September of each year. Staff recommends proposal of this rule amendment. Well, you're approving the proposal of it. It then goes out for public comment.
Got it.
It's
Commissioners, any questions on the proposal of the amendment to the existing rule regarding the unqualified standardbred horses? Don't all jump out. Okay. May I have a motion?
So moved.
Second.
All in favor?
Aye.
Motion carries. Rob, please call the next item.
For Commission's consideration is a proposed technical revision to the standardbred racing rules definition of the term wire, which denotes the finish line of the race. The proposed amendment allows a definition that is more flexible, allowing greater use of technology when appropriate. Staff recommends the proposal of this rule amendment.
Commissioners, any questions on the proposal of the amendment to the existing rule regarding the standardbred definition of wire? Apparently it's not around the 3/4 pole when people start yelling wire, hoping that they're, may I have a motion to propose these amendments?
So just one brief question. The rule says it's the finish line. Isn't it also the starting line?
Not necessarily.
When they go wire to wire?
Start to finish can be an open term depending on where the start is.
Right.
Wire to wire is more, you could start 3/4 of a mile,
Right, I understand.
longer.
But isn't that also called the wire?
No, it's a term of art. It's the starting gate to the wire itself.
Right.
Rob, chime in.
The,
Ron?
No. I think you're absolutely right, that's how it's always been, because you have the starting gate moves, and so technically it's not the wire, it's moving.
depending upon the
Yeah.
length of the race.
I
So
think it comes
why are
from-
we calling it a finish line if it's also the starting line?
Well, it's not always the starting line. They don't always race the same distance.
But this is saying it is always the finish line. It's being defined exclusively as the finish line. This is saying it can never be the starting line. And a horse could never go wire to wire.
Okay,
Well, wire to wire, I think, is a colloquial expression. It's not an expression known in the racing rules.
I think it would be just as valid if the word finish came out. It's a real or imaginary line.
Well, it depends on how we're using it in the rules, right? I mean, if what they mean in the rules is finish line, and they're adopting the use of the word wire for finish line in the rules, then we have to just respect the construction. But if they're using it to mean something other than the finish line, maybe you're saying, maybe we shouldn't use the word wire, we should just say finish line. I don't know, I'll defer to the rule makers, the drafters, I should say.
Is that common enough parlance in the,
I
not in
think-
racing terms? I think the wire is it's always been the term for like the finish line, so.
If it's exclusively the finish line, then that's fine. Of course, that's what we're saying.
That's correct, that is exactly what it says.
Just a-
Okay, so we'll officially define wire as being the finish line.
yes? Great point. So if we are, do we have to modify the amendment?
No, I don't think so. I think we're agreeing that we're using the word wire in all cases to mean the finish line.
That's correct.
Okay. So, do you have a motion to propose these amendments?
Yes, so moved.
Second.
All in favor?
Aye.
None opposed? Motion carries. Rob, will you call the next item?
Item 4E, I'd like you to reference the amended text that was distributed to you this morning. For the Commissioner's consideration of proposed revisions to the horse racing rules in relation to the cost and frequency of post-race testing of claimed horses to determine whether an impermissible drug or other substance was administered to the horse. A positive test, of course, gives the claimant the option to void the claim. These proposals would discontinue the Commission's universal post-race sampling of claimed horses and replace it with a program of sampling at the expense of the claimant when the claimant requests this service on the claim form. The purpose of the proposal is to eliminate the burdensome state expense of testing every claimed horse. Many claimants do not elect to void a claim even if the sample tests positive, and New York is the only major racing commission to provide unrequested free sampling of every claimed horse. The stewards and judges would retain their discretion to order post-race sampling of any horse at the expense of the commission. Positive test results for these samples would continue to provide a claimant with the option to void a claim. Staff recommends proposal of these rule amendments.
This was the topic of some this was something that was debated briefly and thought that we wanted to understand a little bit better the implication to the budget of this rule.
Yeah.
Of this
Yeah, we had a lot of
proposed rule.
questions.
And so in that thought process, until we get some of those, it probably makes sense to think about this and get some of those answers.
And to put on the record, several commissioners had identified to me the concerns relative to the cost of the program, how much the savings would be, what kind of monies would be transferred to the individual owners, et cetera. And to that end, I think I have a general sense of the materials that you're looking for, and we'll have staff develop that. So you'd like us to lay this aside until those materials are received and circulated?
Thank you.
Yes.
Yes, that'd be best.
Thank you.
Thank you, Rob. Okay, well, Rob, would you call the next item?
As item 4F, I'd like you also to refer to the amended text that was distributed earlier this morning. For commission consideration are proposed amendments to various rules that would explicitly authorize the supervised use of veterinary technicians at New York racetracks. The purpose of these proposals is to make it more feasible for horse persons and racetracks to provide an appropriate veterinary care by permitting the use of supervised veterinary technicians. These proposals would create a specific license category for veterinary technicians and would apply to such personnel the same license fee and restrictions for record keeping, horse ownership, the possession and disposal of needles and drugs as currently apply to veterinarians. Additionally, commission approval of employment by a racetrack would apply as it presently does to veterinarians. The proposals would also require that such personnel act under the direction and general supervision of a licensed veterinarian. Veterinary technician is a regulated profession subject to professional state Department of Education licensing requirements, including continuing education, and are competent to perform certain functions, quote, at the direction and under the general supervision of a licensed veterinarian. These proposals also make stylistic changes to the applicable commission rules. Staff recommends proposal of these rule amendments.
Any questions?
This is like a PA, like a physician's assistant.
Correct.
So is it anticipated that the veterinarian who is either supervising or directing this technician will sign off on the records that are created by the technician?
But I don't know.
You know what I'm saying?
Did
Because
we ever open the
Yeah.
line for
Yeah.
Scott? Scott, are you on the phone?
Yes, I am.
On the phone is State Equine Medical Director, Dr. Scott Palmer. Did you hear the question of Commissioner Machete?
Yes. Typically, veterinarians are required to be responsible for any actions performed by a licensed veterinary technician under their supervision, which would include signing off on any records that would be generated by the technician.
What's the genesis of this? Why do we need this added?
Well, at the moment, there already are some technicians working at the racetrack, and there's no general provision for this. This would enable an increase in the amount of veterinary care provided to horses, because it would enable a veterinarian to leverage, his professional expertise by hiring technicians to enable him to perform work more efficiently at the racetrack. It would also potentially represent a decrease in cost to the racetracks to hire veterinarians or veterinary technicians to do such things as administer LASIX or participate in the LASIX program, perhaps, so that there are benefits to the racetrack and benefits to the practitioners for having the ability to hire these people, just as in the same way that they would leverage their professional services in a private practice environment.
Is this done in other states, Dr. Palmer?
I'm not sure about that.
I mean, what is the control mechanism then? I mean, the veterinarians are responsible for themselves. There's issues from time to time, but they're accountable for their own actions. We're now creating a subclass of people who are going to report to the veterinarians and be responsible. Who's responsible, and then how does that reporting work?
Well, in the Department of Education program, there certainly are licensed veterinary technicians that work for veterinarians outside the racetrack, and in all circumstances, any actions that are performed by these individuals are responsible to the veterinarian that is an employer. That veterinarian is responsible for any problems that occur, any complications that occur for treatment, or any procedures that are performed, and that person is held accountable. The veterinarian is held accountable to the State Department of Education.
So if a veterinary technician's working in the racetrack and performs something inappropriately, it's the veterinarian who ends up bearing the responsibility of his actions?
Exactly.
He's vicariously liable then for the conduct of the technician.
Because they're absolutely liable for the conduct of the technicians.
So who charts the veterinarian technicians?
Forgive me, I didn't hear you.
Who charts them? If someone comes in to work on a horse and they say, oh no, I'm the veterinarian technician. A, how do you know who he is? And B, how is that accountability passed back to the veterinarian?
Well, if this person has to be licensed on a racetrack, just as any veterinarian would be, and the veterinarian would have to provide supervisory responsibility. General supervision means that it doesn't mean he has to be standing there, he or she standing there at the time that any procedure is performed, but it does mean that the person that they're ultimately responsible for that conduct. So what that means is, for example, a person would not ordinarily walk into a stall and do anything without some type of an introduction or some type of a professional relationship with the client. So I don't think it's a situation that I would be concerned about.
Yeah, it's not the client I'm asking about. It's more on the regulatory side. If you had someone who was acting inappropriately, how would you know that person A was responsible to veterinarian B and acting under his guidance?
There'd have to be some type of documentation of that employment be part of the licensing process. So if a person was licensed as a veterinary technician, they would have to indicate what veterinarian they were working for. So there would absolutely be accountability through the licensing process.
Doctor, can the technician work for two different veterinarians? So, you know what I'm saying, so that they could...
Ordinarily not. I mean, I guess it's certainly possible with a time-sharing situation, but ordinarily not. If they would certainly have to be documented to both veterinarians in some fashion.
Well, if it was a group practice of veterinarians, could different vets be the supervisor for one particular technician?
Ordinarily, different veterinarians could be a supervisor depending upon who was on duty in a group practice.
And they're licensed now, the veterinarian technicians, by the state?
Yes, they are.
And they're licensed at the track to operate?
Yes, they are. There's not many of them. I met one the other day actually that works in the LASIX barn, helps the veterinarian administer LASIX to horses, and actually helps in the collection of blood samples for TCO2 testing.
At present, they're licensed under general services hyphen vet tech. This would create a specific standard category for that important job rather than bringing it in under the general services requirement. So hence the reason why some of the other restrictions that are otherwise applicable to a veterinarian would then be applicable to the veterinary tech, where right now as a general services licensee, those are not applicable. So basically professionalize, it creates the professional category of the veterinary tech as a licensed occupation, as opposed to using it as a catch-all in general services.
I mean, is there a way to
I
make
think
it,
also the use of the licensing language in here, in this rule would also help to upgrade the qualifications of somebody performing this service. In other words, there are in many states veterinarians who hire non-licensed technicians, and this rule specifically makes reference to licensed technicians, which really is another level of training and qualification that has to be attained to get that kind of license. What that means is that putting this into effect would make it more certain that the person performing the service is properly trained and is participating in the continuing education program.
Isn't that technicians now, or this past season, or even at Belmont, I suppose, are working unlicensed? No. So they're licensed by the state of New York?
They're licensed, first of all, they're licensed as a veterinary technician under the Department of Education. Secondly, on racetracks themselves, because there is no specific category for veterinary technician, they are licensed as a general services employee.
I understand, thank you.
is there a way to make it clear the veterinarian technician is working for a vet? So it's not subjected to any ambiguity?
Scott, I can address that. This is Rick Goodell. The term general supervision means that the veterinarian is aware of what treatment is being provided and has approved the veterinarian technician to go and perform that service. So our rule and the state education rules require that the veterinarian be aware of what's happening and approve it. And that would apply to all treatments.
Yes, that last thing that I had read was the quote, the direction and under the general supervision of a licensed veterinarian comes out of the Department of Education's veterinary technicians licensing section.
Good. Anything else?
Nothing.
Motion?
So moved.
Second?
Second.
All in favor?
Aye.
None opposed? The motion carries. Rob, we call the next item,
As item
please.
4G, for Commission's consideration is a proposed amendment of an outdated thoroughbred horse racing rule. The proposal would delete the provision for extra weight allowance for an apprentice jockey who continues to ride for the jockey's original contract employer. This provision was adopted to reward stables that brought a young jockey into racing through a now defunct system of a jockey needing a sponsoring stable for housing, food, medical care, training, and eligibility for a jockey license. Staff recommends the proposal of these rule amendments.
Should we be getting rid of the weight allowance?
No.
No, it would
Just
just
for
get
the-
rid of the, you wouldn't be, a year longer, you wouldn't get a
Right.
$3 allowance.
Any other comments? Do I have a motion?
So moved.
Second.
Second? All in favor?
Aye.
None opposed? Motion carries. Robert, you please call the next item.
As item 4H for the Commission's consideration of proposed revisions to horse racing rules in relation to the 48-hour restricted time period for pre-race medication of horses. These proposals would no longer permit the use of more than one non-steroidal anti-inflammatory drug, or NSAID, within 1 week of racing. Currently, New York permits the use of various non-steroidal anti-inflammatory drugs until 48 hours before racing, which allows humane and beneficial veterinary care to be provided for mild inflammation. The duration of effect of such NSAIDs, when administered singly, will dissipate by race day. These drugs can be administered in combinations, however, that increase the potency and duration of the effect of the drugs. Thus, when two non-steroidal anti-inflammatory drugs that are administered in subclinical doses inside of 48 hours before racing, which is not permissible, can be effective on race day, but the concentrations found by the Commission's testing laboratory will be indistinguishable from two standard doses that are given permissively at least 48 hours before racing. Further, clinical doses that are given at least 48 hours before racing could remain efficacious on race day. These uses, which interfere with the ability to detect illegal administrations within 48 hours of racing and potentially endanger the health and safety of the horses and the drivers or jockeys on race day, are not necessary to provide veterinary care to a horse that is actively racing. The restriction on the use of non-steroidal anti-inflammatory drugs to 1 week before racing, except allowing one to be used until 48 hours before racing, addresses these concerns while permitting the appropriate use of the NSAIDs. These proposals also make stylistic changes. Staff recommends the proposal of these rule amendments.
Commissioners, any questions or comments on the proposal of these amendments?
Seems like a good step, a positive step moving forward to eliminate race day drugs in horses, even around race day and around, for the health and benefit of the horse. Seems on its face.
Anyone else? Do I have a motion?
So moved.
Second? Second, all in favor?
Aye.
Motion carries. Rob, would you please call the next item?
Certainly. Item 4I, for Commission's consideration is a proposed revision to the horse racing rules that strictly regulate the use of anabolic steroids in racehorses. This proposal would discontinue the permissive presence at threshold amounts of stenozolol, the only anabolic steroid that is neither endogenous to a horse nor already banned by the Commission. The Commission's prohibition of anabolic steroids includes permissible threshold amounts for 4 anabolic steroids. 3 of these exceptions are for endogenous substances that are naturally present in a horse, and their thresholds are at a concentration that occurs naturally in a horse. This proposal phases out the permissible threshold amount for the anabolic steroid stenozolol, as some horses have been lawfully administered this drug well before racing and thus complied with the current permissive threshold use. Staff recommends that the proposed ban on any amount of this drug be scheduled to take effect 6 months after the adoption of the rule change. This proposal is consistent with national rulemaking proposals and with the Commission's intended prohibition of administration of an anabolic steroid to any horse that is actively racing. Staff recommends proposal of these rule amendments.
Are there other anabolic steroids used in this regard?
Dr. Palmer?
There are a couple of anabolic steroids that are used. This refers to Winstrol, is the product that we're talking about. And this is consistent with the general trend of racing to reduce the amount of these drugs used in a racehorse. There are certainly legitimate indications for these drugs in non-racing horses to recover, for example, from a severe illness. They help rebuild the body up. But there's a strong, long-term, strong incentive to eliminate these drugs in racing horses. So I think this is a very good mechanism to take up.
There you go. Any other discussion or comments? Do you have a motion?
So moved.
Second?
Second.
All in favor?
Aye.
The motion carries. Rob, would you please call the next item?
Yes, is item 4J. For Commission's consideration is a proposed revision to the coupled entries rule for standardbred races. The proposals would apply to the revisions that the Commission recently made to rules for coupled entries for thoroughbred races. These proposals would provide that for stakes races of $25,000 or more, separately owned horses having the same trainer may be uncoupled, although horses owned and trained by the same trainer would continue to be coupled entries. For stakes races of $100,000 or more, all horses with common ownership may be uncoupled. In both cases, the uncoupling of the horses would be subject to the discretion of the presiding judge to couple the entries if in the interests of the wagering public. Staff recommends proposal of this rule amendment.
Any questions or comments on this one?
Could you give an example of when the presiding judge may use his discretion to,
Mr. Ruffin?
I think when you have a situation where there might be a minor ownership of a horse, and he feels that one of them maybe has maybe 25%, and he owns the other horse, he may feel that there's really joint ownership of both horses, so you might want to couple them.
thank you, Ron.
Any other comments? Do I have a motion?
So moved.
Second.
All in favor?
Aye.
Aye, motion carries. Rob, would you please call the next motion? Next item.
For the Commission's consideration of proposed revisions to the horse racing rules in relation to the use or removal of hopples for standard-bred horses. Hopples are a strap that keeps the foreleg and hind legs together on each side of a horse in order to keep the legs on the same side moving in unison. These proposals derive from the modern consensus that in the standard-bred industry and with regulators that typically standard-bred horses are able to race regardless of a change of equipment, and that the wagering public can handicap properly based on information in the race program. These proposals would allow the trainer discretion when entering a horse to change, or to race to change whether a horse will use hopples or not, subject to oversight by the commission judges at the racetrack. The disqualification rule would no longer require the judge's permission for a horse's first use of hopples, and instead, the program would be required to report any changes in a horse's use of hopples. The amendments would also allow a trainer more flexibility to change hopples as appropriate for local track configurations and conditions without incurring the time and expense of requalifying a horse. Staff recommends the proposal of these rule amendments.
Commissioners, any questions or comments on the proposal, the amendment to the existing rule regarding hopples? None, do we have a motion?
I'll move adoption.
Second? All in favor?
Aye.
Aye. Rob, would you please call the next item?
As item 4L, for Commission's consideration of proposed revisions to horse racing rules in relation to the qualifications for an occupational license as a thoroughbred trainer or assistant trainer. This proposal would require that all thoroughbred trainers, including assistant and private trainers, have continuing education of at least 4 hours each year. The Jockey Club has developed and is offering online programs for thoroughbred trainers, and the stewards have provided continuing education programs for interested trainers for many years at New York racetracks. This proposal includes an exemption for a trainer who rarely participates in New York racing, subject to the permission of the state steward. Commission staff has participated in extensive discussions in the thoroughbred industry regarding this proposal and is planning to initiate discussions with standardbred interests to prepare a similar program. Staff recommends proposal of these rule amendments.
I just had one question. Are they videos or are they horses?
Scott, Dr. Palmer?
There's a combination of things that are available for continuing education of trainers and assistant trainers. The Jockey Club has something called Advanced Horsemanship Program, which is an online program where you can register, and then you can call up these modules on the computer, and it walks you through the process. They generally take an hour or a little more than an hour to complete. You have to answer questions along the way in order to work your way through the program. And then when it's all done, the Jockey Club has a system for notifying the racing commission, so participation of the trainers, so they get credit for it. There are also
How does the commission approve the programs? Is there a body or group that approves them?
What would happen is a commission would be reviewing these programs, for example, programs given by universities or recognized continuing education providers would pretty nearly automatically get approved, but we will have to have a process where we will have an approval process for programs to be used for this. It's not a difficult thing to keep track of, but typically the individual that's providing the continuing education would need to send a letter to the commission to get approval for programs, and programs such as the Johnny Club program would be automatically accepted, and programs by any recognized provider could also be accepted.
Doctor, what's the mechanism to make sure that you have compliance?
Compliance. Oh, well, that's certainly what would happen. We have a record. The commission will be keeping a record of the hours completed by the individuals in our database, and that database will be used as a reference when the individual goes to reapply for his license. And if there is not an adequate amount of continuing education in the database for him or her, then that individual would have to get more in order to get the license.
Right, because like with continuing legal education, lawyers are required to sign an affidavit during the period of time when they're supposed to have these particular credits, affirming or swearing that they had completed the requisite number of hours, and they're also put down those hours. And they hold proof by way of a certificate, but they don't put those in. So the compliance comes, it's self-compliance, but then if they call, the person is called on to show that they actually did the hours they put down in the affidavit, they have the certificates to show that. Because you guys would have to review all the trainers, right, periodically to see if they comply. Yeah, I know.
It's generally a three-year renewal process right now for the licensing that we'd have to look at in terms of how we would make that work in 4 hours per year. But your point's a very good one, that an affidavit or some kind of a certificate, would certainly work to document the participation. But if the Jockey Club, for example, is notifying the commissions of these completed forms, there's certainly a database that can be established by the commission as well to streamline that process a little bit.
Thank you.
What's the cost involved?
There's no cost involved at this point. There could be. I mean, a continuing education provider certainly has a right to charge for their continuing education, but at this point, the advanced sportsmanship program by the Jockey Club is free, and the education programs that are provided by the state of New York, either by me or by the university, there's no charge for those at this time.
Anything else? Do I have a motion to propose these amendments?
So moved.
A second?
Second.
All in favor?
Aye.
Unopposed? Motion carries. Rob, would you please call item M?
Item M. I would, again, like you to reference the text that was passed out this morning. For Commission's consideration of proposed revisions to the Commission's parimutuel authorized wagering rules in relation to Pick 4, Pick 5, and Pick 6 pools on thoroughbred horse races. These proposals would make such wagers consistent by eliminating rule discrepancies that arose when such wagers were authorized incrementally over a period of many years, and would standardize some of the potential common occurrences with wagers of similar nature. In general, the proposals would provide that if a horse were scratched from a race, then the substitute entry for bettors in the pick N pool would be the betting favorite in the win pool at the close of wagering on the race. If identical sums were wagered on more than one horse, then the horse with the lowest program number would be substituted. If there are surface changes, for instance due to weather conditions, or races in a pick N race, then the pick N would be canceled when no bettor has correctly selected the winner in at least one race that is run on its original surface. Otherwise, the pick N will be determined as every other bet on the races with the surface changes were winning bets on such races. The amendments also establish a consistent practice so that when a certain number of races in a pick N are canceled, the pool is also canceled. Finally, these proposals also formally insert pick 5 pool wagering into the commission rules, also makes grammatical and other stylistic changes, and renumbers the rules in serial order. The amendments were formulated in consultation with the New York Racing Association, which supports the proposals. We specifically thank NYRA Senior Vice President of Parimutuel Operations Patrick Mahoney and Vice President and Chief Revenue Officer David O'Rourke for their assistance and guidance during the drafting processes. Staff recommends proposal of these rule amendments.
Commissioners, any questions on the proposals? When they did this originally, they provided some financial results as way of backup for the PIC 4 not being cannibalized by the PIC 5, PIC 6. You know, at the time, it was a reasonably short period of time before they looked at it. I forget what the length was. I don't know if it was a year. But I think it'd be good to sort of have that brought back now and take a look at it in the totality of sort of a longer prism of time. Is that possible to get something like that?
Absolutely.
Sure.
Ron Okram actually follows this and has been tabulating
And
this.
it also was about the cannibalization of both. I remember we
Yeah.
saw before, there was a mild cannibalization
It's
of the
very
PIC
mild.
4, but it was a big uptick in.
It's still very mild. I mean, the Saratoga meat was very successful with PIC 5. It's the highest on average, and the PIC 6 actually went through the roof at the Saratoga meet. So they've been doing very well. PIC 4 is basically been holding its own.
The problem with Saratoga in general is that the results are always so wonderful. Hard to skew it across the other
Well, with the PIC 6,
300 and some odd
they-
days you race, right?
they had 19 carryovers this year, so
But
they
no, I
had
remember.
incredible.
Yeah, and you had a lot of
PIC 6
horses, and you
and-
had very great weather, so you'd have a lot of cancellation and sort of goofy things, but it was more concern overall through a calendar year.
Yeah. And we do monitor that, and like I said, the PIC 4 has basically been holding pretty well, except for the aqueduct meet, it was a little lower. But generally, it's been holding its own since we've instituted the PIC 5.
But
And the 5 has done tremendously well.
we'd certainly be able to provide
But we can get you the.
updated
Yeah,
materials.
Take a look at it,
Yeah.
right? I mean, it was positive before, whatever the cannibalization was crushed by what the uptick in the Big 5 was. Yeah. Any other comments? Is there a motion? Propose these
So
amendments.
moved.
So moved, the second. All in favor?
Aye.
None opposed, the motion carries. Rob, would you please call the next item, item N?
Which
Mercy.
is the last of the rule proposals. Again, I please reference you to the amended text that was distributed this morning. As item 4N for commission consideration or proposed revisions to horse racing rules that regulate the use of certain substances with per se thresholds and restricted time periods. These proposals would align the commission's laboratory thresholds for controlled therapeutic medications with the latest ones approved by the Association of Racing Commissioners International, or RCI. RCI recommends adding a threshold for albuterol, a bronchodilator, and lowering the threshold for ketoprofen, a non-steroidal anti-inflammatory drug. Both recommendations are consistent with the Commission's existing time restrictions for albuterol and for non-steroidal anti-inflammatory drugs that ensure a horse person will not inadvertently commit threshold violations. RCI's Scientific Advisory Committee also recommends adopting 2 thresholds for cobalt, which is a dietary element. One threshold at 50 nanograms per milliliter regards the detection of intentional overuse of cobalt, a practice that has no valid purpose and cannot occur without using refined products. The second threshold at 300 nanograms per milliliter would impose a blood doping level penalty when the violation has undeniably occurred. Cobalt is reportedly misused in a manner that causes adverse effects in horses, including clinical signs of abdominal pain, as well as a blood doping effect. Finally, the proposal would also add a threshold for isofluprednone, a corticosteroid, restrict its use to only joint injections, and establish a requirement that the Commission first warn a trainer whose horse tests in excess of corticosteroid thresholds when the corticosteroid joint injection causing the threshold violation is shown in documentary evidence, which is pre-race reports to the Commission or veterinary records. And when those reports have been indicate that they were safely administered in compliance with the Commission's 7-day restricted time period for thoroughbred races. Unlike the other proposals, these corticosteroid rule proposals are limited to one breed because the commission has differing standards for them. Staff recommends the proposal of these rule amendments as well.
Any comments or questions?
Dr. Palmer, cobalt, can you tell us what that is? I know it's a dietary element, but I don't know what that is.
Cobalt is a component in a number of valid therapeutic medications, for example, vitamin B12 and B complex, and a number of products include a number of types of B vitamins, include cobalt in them. Cobalt is also present in certain seeds that can be given to horses. It's also present in feed supplements that can be given to horses. Research has been done to show that, well, basically a little bit of cobalt goes a long way. It's a very useful element. It's an important element in terms of production of red blood cells, keeping animals healthy, and humans as well. But the problem that we're confronted with is that cobalt salts, cobalt sulfate, for example, is given in large doses intravenously to horses and causes some real health issues with the horses, and does seem to have a blood doping effect. The mechanism isn't entirely clear, but it's a real problem. And so the Racing Commission International and the RPC has been working mightily with this for a couple of years now to come up with recommendations, because it is a natural element in the body. There was a lot of controversy early on about the threshold levels that should be used to determine whether or not this element is normally in the system or is it abnormally added to the system, if you will. And these thresholds now have been validated, and feel very comfortable that the 15 and 300 represents some pretty good indications of the overuse of this substance. So this proposal, as it's written, gives the commission the ability to allow people to use cobalt appropriately as a supplement, for example, or in the feed, or even in intravenous doses, small doses. But it also recognizes when a person has given excessive doses of medication where it could be a blood doping agent that cause harm to the horse, and apply appropriate penalties for that.
Thank you.
Any other comments or questions on the amendment?
There's a special provision, as I saw in the rules, about the fact that if there's a positive with respect to the corticosteroid joint injections, then if the trainer can, I guess, produce veterinarian records that it was administered within the time frame or outside, 7 days or back, or however it's judged, that's an absolute defense. Is that a provision that we've seen in other drug issues with respect to horses?
Yes, we have. Dr. Palmer, would you like to address that as well?
We have had some situations with the new adoption of the National Uniform Medication Program. There are a number of corticosteroids that are regulated by that program, and the challenge of setting up these rules initially was that these drugs are given in innumerable fashions and in different doses, different locations, both in the joint, outside the joint. And so it was quite a challenge to figure out how to regulate these corticosteroids in a way that would be appropriate, so that these medications could be appropriately used, but regulate against inappropriate use of these medications. So one of the big things that the RPC did is perform studies and looked at particular dosages of particular drugs in one joint, for example. And then because it's frankly impossible to perform studies that would include every possible combination of dosage and joint combinations, multiple joint combinations, that we were forced to consider mitigating circumstances. As, for example, the rule would say you can only give 9 milligrams in one joint. This would be the threshold. What happens if you inject 2 joints? Then what happens? And so we went through a process of acquiring information for more than 2 years, actually, looking at what would happen if multiple joints were injected, if different doses were used. And it really helped us to clarify, what could be mitigating circumstances or aggravating circumstances, given the nature of a corticosteroid finding by the laboratory. And because that we don't have a rule for every possible combination, the decision was made that in the first time something like this would occur, we would notify the individual involved, the trainer and the veterinarian, discuss the situation with them, simply to just use exceeded or threshold and provide an opportunity then for them to make corrections and basically give them a warning for that. There would not be a warning for a second offense. So that's a policy we use for betamethasone, for example, recently. And it would be the same policy for isoflurane, used in the same way.
But my question is with respect to the production of the veterinarian records, because as I understand this, it says basically if there's a positive drug test, right?
Right.
Then the trainer has the opportunity to produce, it says contemporaneous vet records to show that the injection was made within the proper time period. That's what I'm asking about. And is that a provision that we have with respect to the administration of other drugs?
Yes, it is. Maybe Rick can comment about that.
Yeah, this is Rick Goodell. If the question is whether we have a production of veterinary record requirement before we enforce laboratory positives in circumstances other than corticosteroid joint injections, the answer is that we request those records in every investigation, that they are not a defense. The corticosteroid joint injection restricted time period, which is 7 days, is the only one that does not ensure trainers that they will not have a threshold violation if they follow the time period. And so the purpose of this is to not have a restricted time period that fails to provide assurances that there won't be a violation, but to give a trainer or veterinarian the benefit of that only if they have properly documented their corticosteroid joint injection.
So how does that work though, Rick? Say there's a positive. Does that mean it's incumbent upon the trainer to produce the records? And they have to show that they were contemporaneous? I don't know how they do that, dates. I guess if it's properly dated, or does the vet himself have to come and deliver the material to you folks?
Yes, in addition, the rule requires that they must have complied with our requirement that they disclose all of their corticosteroid joint injections pre-race. So that would give us an added assurance that the veterinary records were accurate. At that point, in conjunction with Dr. Palmer and Dr. Malin, a judgment would be made whether the documented administration would account for the laboratory finding.
I mean, the concern would be that they're contemporaneous, right? That the records were kept contemporaneous with the injection.
Correct.
Thank you.
Any other comments or questions? Peter, you okay?
Yeah.
Motion to propose these, motion to propose these amendments.
So moved.
Second.
All in favor?
Aye.
Aye, none opposed, and the motion carries. Rob, will you please pull the next item?
The next item are adjudications. We have 2 hearing officer reports for consideration today. The first is in the matter of Michael Brown. On August 6, 2015, the Bureau of Licensing declined to issue Michael Brown a general services license. The denial was based on the conclusion that his experience, character, or general fitness is such that his participation in racing or related activities would be inconsistent with the public interest, convenience, or necessity, or with the best interest of racing generally. Specifically, Mr. Brown made a false statement on his license application regarding his criminal history. After Mr. Brown appealed, a hearing was conducted on August 25th. The hearing officer report and recommendations were delivered to the Commission Secretary on September 3rd. The hearing officer recommended that the license denial be upheld. At a meeting conducted pursuant to the judicial or quasi-judicial proceedings exemption in the New York Public Officers Law, Section 108.1, the Commission considered this matter.
The commission did deliberate this matter and considered it. There was a vote, it was 5-0, but I'm going to ask my colleague, Commissioner Michetti, to explain some thoughts that were expressed.
In looking at the hearing record, I mean, it's clear that the evidence was overwhelming. But my concern, and I think the concern of some others, was that in looking at the due process here, this is a pro se respondent or applicant, so he doesn't have a lawyer. but he is entitled to the same rights as someone who would come to the hearing represented by counsel. And when the hearing officer conducted the hearing, to me, it was done differently than they are usually done and should be done, in that the applicant here did not have an opportunity to present his side of the story in a essentially direct examination. Now, he would have to do it as a narrative because there would be no one asking questions. What happened, at least from a reading of the record, is that he was sworn, but then the attorney for the commission then began to cross-examine him, thereby depriving him of the opportunity to explain himself in a narrative about his position and why he thought that the decision was incorrect. So I would think and hope in the future that the hearing officers are consistent in the way they conduct the hearings, such that they make sure that the pro se applicants, along with those that are represented by counsel, are afforded the same due process. That being, they have an opportunity to present their case without interference and without having to worry about being cross-examined before they even offer their defense in the case. And that was just my concern.
Mr. Burns, are we capable of providing that concern to our hearing officer?
Yeah, absolutely. I'll write a memorandum to all of the hearing officers and CC Commission Counsel summarizing the concern in this particular case and generalizing it to all hearings going forward.
Thank you.
So while we voted 5-0, there was a strong sense, I think, among my colleagues that Mr. Brown should reapply with an application that was conforming with the questions that were asked to him.
Yes, we felt strongly about that.
Yes, that the process will be upheld, but
We'll make certain that sentiment is reflected in communications to Mr. Brown.
I think we also had talked about the language on the application.
yes.
And the consensus, I believe, was that we need to improve that language so that applicants fully understand that no matter what they think about what happened to any prior arrest or conviction, they need to put it on the form that they were arrested, and the failure to do so is going to mean that they're not going to end up being licensed. So that if they have questions or they're unsure, they should ask or make inquiry to whoever, whether it's the commissioner, someone that would have knowledge.
They should make an inquiry of either someone from the commission or from NYRA, if that's who the form is from.
Yeah, someone other than an outside influence that may not know the rules as they are applied in this form.
Yeah, I don't think it's too strong to say that there's sort of a consensus view that we're seeing far too many of these appeals that seem to be based on a mistaken interpretation of the questionnaire. And we'd like to not see these cases if clarification of the questionnaire can help it.
We will certainly hold a meeting with licensing staff to review the applications, review the language, and see if we can conform the language that we utilize in those applications to address your concerns.
I think you guys said you would be kind enough to send that language to us or provide it to us so we can take a look at it before.
We certainly will.
All right. Item B, Rob?
This is in the matter of the disqualification and placement of the horse Kiwi Ideal N. On February 28, 2015, the standard-bred Kiwi Ideal N raced at Yonkers Raceway. The horse had finished first in the 10th race that day, but was disqualified by the judges and placed 8th for failing to maintain the pace and causing confusion. Darren F. Kassar, the owner of the subject horse, appealed the judge's placement decision on March 7th. On August 4th, the commission brought a motion to dismiss the appeal and requested that the claim be resolved by summary judgment. The hearing officer considered the motion and response papers thereafter. The hearing officer's report and recommendation were delivered to the commission secretary on September 15th. The hearing officer recommended that the motion of the commission for summary judgment and dismissal of the appeal be granted, and that the placement determination of the judges be upheld. At a meeting conducted pursuant to the judicial or quasi-judicial proceedings exemption of the New York Public Officers Law, section 108.1, the commission considered this matter.
The commission did consider this matter, duly deliberated, and came to a 5-0 vote.
To sustain?
To sustain the decision. The hearing officers report. Item number 6, old business. Are there any items on the agenda that are old business to consider?
We have none formal.
I guess the one we kind of thought about was, we haven't heard anything about the LASIX follow-up.
Actually, Commissioner Machete had mentioned that he was reading something, I think on the train down, relative to some new research.
Oh, that they're apparently, is the Grayson Jockey Club?
Yes.
Is going to conduct some research into, I guess, the efficacy of LASIX 24 hours before race time. So it would not be race day administration of LASIX. And so, consistent with what we heard at the forum that the commission held on LASIX, there's a paucity of research on the issue. So they're going to research that, the effect of equine exercise-induced hemorrhaging, or I should say exercise-induced hemorrhaging, and apparently issue a report on that. And I think that's being funded by a number of groups, a number of the racetracks, including NYRA.
Including that. We also note that Kentucky's attempt to propose some regulations that would allow for the carting of non-LASIX races. The regulation has been rejected in the manner that they have for their regulatory processes, and is now back to the authority for reevaluation.
Maybe we could take a look at some of that.
I can certainly gather those materials.
There were other items that we said we're going to follow up on, size of the LASIX industry.
Yeah, we haven't gotten that materials.
Right, and I think it's worth sort of exploring both here and potentially in the New York Breeders' Fund, sort of thinking about what are some relevant ways to do that. It didn't seem to me, it wasn't clear that there was a lack of number of tests. There was a lack of effective tests. Certainly everyone was referencing the study somewhere, and the innuendos were made a lot of different comments about things that perhaps weren't showing up.
But there were a lot of comments not backed by any studies.
Correct. I think just an awful lot of stuff. I think we should adhere to sort of go through the process of figuring out what was real and not real, what's possible to sort of help be effective in that dialogue.
We're still in the process of gathering the materials that were previously requested.
John, if you want to send me a note, I'll put it on the agenda for the next meeting of the fund board.
Yeah, I'd be interested to hear the breeder's perspective on, you're creating the super horse, you're certainly spending a lot of money on it. How does that factor into your decision-making process? They're being bred to win grade 1s, but there's obvious benefit for them winning here in New York. Maybe there's something to think about there. Any other new business, old business?
No.
I'd like to congratulate Saratoga Raceway on their triple dead heat. Looking forward to seeing that in the not so distant future.
We all request copies.
Yeah, we all would like to see a copy of that. I think that's a fairly exciting outcome, and wish it was a little bit easier to access. With that, the next meeting of the commission is scheduled for October 26th. You talk to Ms. Buckley, advisor is your availability.
I believe the primary meeting location of that, Lee, is in Manhattan.
Yes, Midtown.
Good show, Lee, thank you.
Yeah. That concludes today's published agenda. Any other items for consideration? Hearing none. Good day.
Thank you, Mr. Chairman.
Great job.
Great job.
Thank you, everybody.